Hi, thanks for visiting worklawyer.ca. I'm Jeff Robles, a partner with the law firm of Riley and Partners Professional Corporation and a Law Society certified specialist in civil litigation. For today, I thought I would try something a little different from what I've done in the past and try a little more informal setup. What I wanted to talk about today was the topic of changed substratum. In employment law, there are numerous topics and terms or concepts that they're not self-explanatory to most lay people. One example is constructive dismissal. Most people know what a wrongful dismissal is, but not everyone understands the concept of a constructive dismissal. When you mention the term mitigation efforts to a layperson in the context of employment law, it's not necessarily the case that they're going to understand, but most employment lawyers do. At the same time, there are other concepts or terms that are obscure even to employment lawyers, and changed substratum, or that doctrine, is one of them. When I came across this concept or topic years ago, I thought to myself, that sounds like something that I studied in my undergraduate days in philosophy, studying metaphysics. However, the change substratum doctrine isn't anywhere near that complex or abstract. The case law tells us that this doctrine applies where there have been fundamental expansions in the employee's duties after the employment contract was made, such that the substratum of the employment contract has disappeared or substantially eroded, or it can be implied that the contract could not have been intended to apply to the role ultimately occupied by the employee. So when we think of the substratum of an employment contract, we can look at it as the underlying foundational terms that make up a job's duties and responsibilities. And over time, over the years, an employee's duties can change so dramatically that the job is no longer reflecting what the terms are in the employment contract. And it was this doctrine that was the focus of the Court of Appeals decision in a case called Celestini and Shop Logics Incorporated, from which that case, that quote rather, that I had mentioned earlier, comes from. Now, in this case, the employee who started the action or started the court case co-founded the employer company Shop Logics Incorporated in 2002. And his original position was as the CEO or the chief executive officer. Now, in 2005, the employee stepped down as the CEO and then became the chief technology officer instead, or the CTO. And at that time, in 2005, he signed an employment contract that provided that if he were let go on a without cause basis, his entitlement or his payment would be 12 months of base salary plus benefits on a prorated basis, a bonus as well. So in 2017, roughly 12 years later after signing that employment contract, the company was bought out by another corporation. Its shares were acquired. And on that same day, the employee was dismissed on a without cause basis. And so, in accordance with the terms of the employment contract, he received those payments that I had just mentioned, the 12 months of base salary plus 12 months of benefits continuation, and then a prorated bonus. Now, afterwards, the employee sued the company for wrongful dismissal and relied upon that changed substratum doctrine. And then after that, after commencing the action, brought a motion for summary judgment. Now, at the motions judge granted judgment in favor of the employee, accepting that changed substratum doctrine argument, and found that the employee's duties had expanded considerably over the course of his employment, and that his new responsibilities were, quote, substantial and far exceeded any predictable or incremental changes to his role that reasonably would have been expected when he started as CTO in 2005. Now, the company then appealed the decision to the Court of Appeal. And on the appeal, the Court of Appeal upheld the motion judge's decision. And in his reasons, Appellate Court Justice Zarnett restated the doctrine, the changed substratum doctrine, as follows. The changed substratum doctrine operates as a limit on when an employee's common law entitlements will be restricted by the express terms of a historical written contract. Given that an employer-employee relationship may evolve in a fundamental way after the written contract was made, the doctrine recognizes the potential inappropriateness and unfairness of applying the contract's termination provisions to circumstances that were not contemplated at the time of contracting. So the Court of Appeal rejects the company's submissions that the doctrine shouldn't apply because the employee's title didn't change, that it remained over the course of those 12 years as Chief Technology Officer, and that his responsibilities hadn't increased to a sufficient degree. But in reaching the decision, the Court of Appeal cited that excerpt from the motion judge's reasons that I had mentioned earlier. In other words, the Court of Appeal agreed that the terms of the employment contract no longer reflected what the employee's job duties and responsibilities were at the time of termination. So in terms of a takeaway from this decision, what I would say is that for employers, it's a good idea to revisit employment contracts from time to time, making sure that the employee's actual duties and responsibilities reflect what is on paper. A good time to do that would be the employee's annual performance review. That's the perfect time to undergo that exercise. Now, if an employee is entitled to a promotion, one that has an expansion of duties and responsibilities, then it makes good sense at that time to revisit the employment agreement and update the written terms of employment. And as this case demonstrates, doing so can reduce the risk of litigation down the road. So that's everything that I wanted to talk about today. Thank you for visiting worklawyer.ca. I hope you found this interesting and informative. If you'd like more information about these and other employment-related topics, feel free to visit worklawyer.ca. Thanks very much, and we'll talk to you on the next one.